Bargell, is this regarding mineral resources or another application specifically?
This is not regarding mineral resources.
Fair enough.
It is, I do have some comments about the rulemaking that if I can make at the end from NARO, I'd appreciate it, or I can just wait until the rulemaking hearing.
If it's rulemaking, I'd actually hold on until staff, but if you have another comment, feel free. So.
Okay, I do have it. I do have another comment. My name is Cindy Bargell. I'm an attorney with Cynthia Bargell. I've appeared before this commission previously. As a board member of NARO, I'm here today as private counsel. I have been in the oil and gas business since 1981 when I received a degree in mineral land management back when they had one from CU. Have been in private practice for 20 years after spending 10 years as a landman. I am here today for a different probably group of the people, of the citizens of the state of Colorado. It's been good to hear from everyone else, but it's representing actually the private mineral interest owners. And there are a couple of issues that we have seen in the recent past that have come to a head and continue to move forward rather rapidly. And I believe deserves some additional time, maybe not in a 2-minute comment. And one is related to the class of individuals that are really being forced pooled right now. In 1998, I think it's safe to say there were 5 to 10 forced pooling hearings a year annually, where maybe 2 or 3 owners couldn't be identified, and the statute was put to work, the statute that has been determined constitutional and around since 1950, to protect those mineral owners' rights, and I believe that's the case. There has been an onslaught, exponential, I don't know what other words you want to use with respect to forced pooling applications in the last 3 years, and they have impacted mineral interest owners throughout the state, many of which who don't fully understand the process, and several of which are very concerned about the current practice of determining that forced pooling should go forward even if it's contrary to the existing lease terms. I did listen, and I very much appreciate the chance to listen to you all from afar, to the hearings in Rifle, and felt it was important to be here in front of you today. I do think that the mineral resources application, while it's been continued, is probably a very good indicator of what you're going to be seeing in the next 15 or 20 years when you have thousands of people who will come in for an interest, potentially as non-operating working interest owners. I also think what you heard today from Mr. Wickstrom probably summarized what a lot of mineral interest owners feel who have recently negotiated leases. Can you still hear me? One of the issues that we've heard is that involuntary pooling occurs as a result after the application is filed and these larger horizontal units are needed. And I don't think you're going to find disagreement on that. Things have changed. Also, Section 116.6 of the statute specifically says that forced pooling is done in the absence of a voluntary agreement to pool. If the parties have voluntarily agreed in a lease agreement to some pooling arrangement, it's difficult for the mineral interest owners to understand why forced pooling occurs. I recognize that you're looking at older leases, but it's not a one-size-fits-all process. Forced pooling is discretionary, that statute says it's discretionary, and it also has to be considered under the terms that are just and reasonable. And if a person negotiated a lease 2 days ago with the full understanding that how their lease is going to be addressed with respect to forced pooling, I'd ask that it's not, or suggest it's not just or reasonable. That's one issue. I think this whole class of mineral interest owners. I also would ask that as we look at the URUs coming up in October, that there's an opportunity to speak, and we'll talk about the rulemaking at that time. Thank you very much.
Thank you.